Hi, everyone. My name is Michael Schillig. I'm a professor of law here at King's College London and also professor of international business law at the University of Leipzig in Germany. It's a pleasure to be here this afternoon. By trade, my area of expertise is corporate law, commercial law, financial law, in the broadest sense, so to speak. And more recently, I got very interested in law and technology. I have to say, I'm not so interested in how to regulate technological innovation and new technologies. But what I'm particularly interested in is whether and to what extent technology and innovation can be used for traditional legal tasks and legal functionalities. So, and I will give you an example during my little talk this afternoon. And in this example, decentralized decision-making, actually drawing on, or I got inspired when I listened to a presentation that Federico gave at one of our workshops here, how decentralized decision-making can be used in the context of restructuring, corporate restructurings.
Hello, I'm Nathan Schneider. I'm a professor of media studies at the University of Colorado Boulder, where I'm proud to be a colleague of Eric Alston, who you just heard from, though I feel like the inferior participant for not being able to make the trip. But good to hear your voice, Eric. I'm also a collaborator of Federica, so I'm really grateful to have the chance to be on this panel together. And one of the projects going on in my lab right now, the Media Economies Design Lab, is around dispute protocols. So really looking forward to this conversation. These ideas have been really front of mind for me. So I wish I could be there all day at this event, because it's just really close to the work that we've been doing over here at MedLab.
Great.
Federica, I lost your audio. I don't know if after I spoke, I haven't heard anything.
You know who I am, so I guess you don't need that.
Okay, there we go.
You don't need that part. But if there's a little time, I'll speak a little bit about this project with Nathan on mining history for examples of decentralized dispute resolution mechanisms and institutions to contribute to the conversation about what these systems might look like in the present. So without further ado, I think that on my list, we start with Michael, so maybe we can follow the order.
Yeah. Perfect. Thank you very much for setting this up. Can I just ask, do we have any lawyers here in the audience? Oh, so quite a few. That's great. Do we have any insolvency lawyers here in the audience? I mean, who isn't an insolvency lawyer these days, I guess? So insolvency law and restructuring law is one of my main areas. And I was quite interested in combining this area of restructuring with new technologies, and in particular blockchain technology and smart contracts. So this is an idea that we've been working on for quite a while. and with the help of a computer scientist, a PhD student who is writing his PhD here at King's, we actually managed to code what we call smart restructuring tokens. Just by way of background, debt restructuring and on the basis of statutory frameworks can be quite a lengthy and costly process. So it works reasonably well under, say, Chapter 11 of the United States Bankruptcy Code, or the Scheme of Arrangement here in England, or the new restructuring plan process. It works reasonably well for large corporates that have the resources to actually fund such a restructuring. It doesn't work so well for smaller entities, for smaller companies. And so we came up with this idea of the smart restructuring tokens, in particular for smaller companies that could not so easily or cannot so easily avail themselves of existing statutory restructuring frameworks. So what we came up with is essentially a model that ensures that every creditor, every capital structure creditor, so the long-term debt within the capital structure of a company and equity, get precisely what they have bargained for ex ante. So this model solves the valuation problem in a restructuring, which is at the heart of why restructurings are so difficult, because the different classes of creditors and equity holders dispute the valuation and argue about the valuation. There are hold-up problems and so on, which makes this quite complicated. So our solution addresses this problem directly. It solves the valuation problem in the sense that everybody gets exactly what they have bargained for ex ante, regardless of what the value of the pool of assets of the company in distress turns out to be. The way we do that is drawing on models that are basically 40 years old, that were developed in the 1990s by people like Barry Adler or Lucien Babchuk in the United States. So what we modeled were options based on two interacting smart contracts, a capital structure smart contract and a restructuring smart contract. Roughly speaking, I don't want to go into too much detail here. As soon as a restructuring is triggered, the junior debt will be converted to new equity tokens. The same for old equity. Old equity gets shareholder call options. Junior debt also gets a type of option. And then depending on an incentive structure, the shareholders exercise these options. If they think there's value in the company, by exercising these options, they pay off debt and junior debt, and they drop out of the picture. But the key takeaway using Babchuk's model is that everybody gets exactly what they have bargained for ex ante, so no one can complain in the end. And this was coded by our coder, and we run tests, and it works, or seems to work. Now, this initial smart restructuring token proposal had one big Achilles heel, and that was the restructuring trigger. Because initially we relied on the company's management triggering this restructuring by sending a transaction message to the capital structure smart contract, and thereby triggering this automated restructuring and the issuing of the new option rights to existing equity and junior debt. Based on traditional legal incentive mechanisms, but we already know that these traditional incentives based on fiduciary duties, trading in the vicinity of insolvency and potential liability for that, we already know that doesn't really work. We know from existing statutory frameworks that these incentives don't really work. So having listened to Federico when he gave his talk, I think it was maybe last year or the year before, I can't quite remember, I realized that perhaps the best way to go about this is to use a Schelling point mechanism. A Schelling point, a trigger mechanism. So we have thus far two interacting smart contracts: a capital structure smart contract, restructuring a smart contract. The one takes care of the initial tokenized debt and equity. Restructuring takes care of the issuing of these option rights, and the new trigger mechanism, smart contract, that is based on the idea that all holders of capital structure debt and equity will participate in a voting mechanism based on Schelling points that any of these participants can trigger. But in order for that to work, obviously they need to have a stake. So the idea is that when any of these participants buys debt or equity in our company, they have to put down a deposit. And this deposit has to be significant enough to provide a proper incentive. It can't be too high so as not to deter investment in the first place. So the calibration of that deposit is sort of a difficult question, but nonetheless, there it is. So this deposit serves as a stake. So if one of our parties, our participants, believes that the company enters financial distress, they can then trigger the voting mechanism. All the participants would vote, and this would be a yes or no vote. If they vote yes, restructuring will be triggered automatically, and this conversion of debt and equity and so on into these option rights occurs. If they say no, that's the end of the matter, and we have to see what the future holds. But in line with the Schelling point idea, those who vote in favor of the prevalent outcome, they will retain their stake and will be rewarded. Those who vote with the losers, they will lose their stake and will therefore be punished. Schelling points, as we know, works on the basis of the idea that there is something special about a situation so that everybody who looks at it can coalesce around that. And as Buterin writes in one of his early papers, the truth might just be precisely that focal point around which people coalesce. And so my thinking is that if financial distress and the need to restructure, if that is the truth, then the likelihood is that the participants will coalesce around that truth, and that truth will then prevail, and vice versa if that isn't the case. So to cut a long story short, by using this Schelling point trigger mechanism, we solve the last sort of problem that has bedeviled our smart restructuring tokens so far. And in that way, we can have a fully decentralized and automated restructuring solution, really for any company or corporation that issues debt and equity in tokenized form. By the way, it doesn't have to be all the debt. What's important is that it is the capital structure debt. So suppliers and customers, obviously, that any debt that is emanating from these participants would not be tokenized in that sense. How am I doing on time? Great. So before I finish, I wanted to say something about Eric's paper, which I found quite fascinating. Because when I listened to you, Eric, I thought, I mean, this makes perfect sense. But then I thought a little bit about it and about the hard cases. I mean, the point about hard cases is that, you know, it could go either way. And even if, say, a majority of the court decides in favor of X rather than Y, then there's a good chance that 50% or 49% of the people affected by it will still disagree with that argumentative effort. So that made me think, maybe it's the hard cases where AI is actually might be more useful, or not just AI, but, you know, like rolling a dice even, because then you would have parties and they could say, well, you know, that was just bad luck. It's not any sort of contrived arguments that I don't really find convincing. It's just bad luck, and that's it. Boom. The dice rolled in favor of Y, and so be it. And you can, you know, build that up a little bit with AI and have a nice story in there. Anyway, just a thought that I thought was quite.
The true. If you think it's randomized in all the true hard cases, then you probably take a pretty dim view as to whether justice is being served, which I might share with you. But then we ladder up to the question of how many people believe that this is what our court systems are doing, and whether they would accept it if it was truly for the issues of greatest social significance. It ladders up to a dice roll. I'm not sure. I think people prefer the illusion, even if it is an illusion. And I mean, this is a debate for. I'm sorry.
It's the question that we had earlier. Would people accept it? And you know that requires some perhaps education. And I also agreed. I used to agree with your starting point about justice. But if in these hard cases, it's really, you know, reasonable people can disagree on whether Bertie or Alice are right, and then sort of this justice argument is not quite as strong. But anyway, thank you very much.
Come back to the question of the nature of law, but eventually, potentially, we should do that in the Q&A. I'm going to pass it on to Sophie.
I think you need to let Nathan in. Is he in? Ah, yes. Thank you. Well, I won't apologize. I would just say I will have more questions than answers. I'm going to talk about dispute resolution as a tool of governance. There is no question that dispute resolution in the courts is a tool of social governance. It resolves disputes. It allows society to go forward. It allows the wheels of commerce to go forward. International arbitration in most of the countries that are members of the New York Convention, which is the treaty that allows the recognition of awards in 153 countries around the world. International arbitration, by virtue largely of that treaty and also of its use over several decades, has also been recognized as a tool of governance. And part of its role as that tool is to be the guardian of the application of the rule of law. Now, we have been talking, we are concerned here in this event about blockchain dispute resolution, decentralized dispute resolution, which is also a tool of governance in the sphere where it operates. Now, the topic of blockchain governance is a very vexed one at the moment. There is no consensus about whether it exists, what it consists of, and how it is enforced. There's very interesting, compelling scholarship that I encourage you to explore if you're interested, notably by Primavera de Filippi on the topic. But the role of dispute resolution as a mechanism to help that governance is very rarely discussed as such. My observation at the moment is that it does not have that role. Now, putting that aside, it doesn't mean it won't, it just doesn't. There is a lot of talk about automatizing, about making things immediate, about making things quick and cheap and accessible, very laudable. How that ties in with the governance role is one of my open questions, because obviously there is a mechanism factor and there's a time factor to that role. Now, going back to the off-chain world, where I do my work as an arbitrator, the rule of law, at the moment, there is an important school of thought led in, amongst others, by Professor Jerry Waldron, who is a noted political and legal philosopher from New Zealand. And he has written a very interesting book in 2023, published at Harvard University Press, called Thoughtfulness and the Rule of Law. And what he says, he talks about thoughtfulness in the following terms, and I'm going to quote him to be accurate. He says, human beings want to be ruled thoughtfully. Or to put it in a democratic idiom, we want our engagement and governance to be thoughtful and reasoned, rather than rigid and mechanical. The rule of law expresses a powerful commitment to dignity and respect for the dignity of human agency in the forms and procedures it requires for law. So this puts, obviously, the human element right in the center of the rule of law. And my question is, what does it mean? How does it coexist with a system that allows disintermediation, that allows decentralization, that allows immediate outcomes? What technology and decentralized dispute resolution forces the off-chain world to do is to rethink what the rule of law means in the off-chain world. You have to have a putting of our own house in order to achieve what Rob's vision is, which is an optimization of the off-chain dispute resolution by technology. You can't just plug in AI into the system in which I work every day. The system is not designed for that. We have, first of all, to look at what data is going to go into the AI. In arbitration, the data is immensely curated by the time I see it. It is drip-fed to me. How can AI help me with that sort of data put into it is my second open question. I will also ask about time. The time factor of all of this is very much at the center of what a dispute resolution system, which is an effective tool of governance, can achieve. We all agree that cases that take 2 years to resolve, if not more, are not an effective tool of governance. However, thoughtfulness, human agency, procedural fairness, all of that is time-laden. There is a time factor to this. It doesn't have to be as long as what we have now. And so again, the off-chain world has to rethink what procedural fairness must mean. It doesn't have to mean 4 rounds of pleadings. It doesn't have to mean document disclosure that leaves me with 5,000 pages. There has to be another way. And what I want to say in this panel, where we talk about the intersection of decentralized and technology and the off-chain world, is that the off-chain world has to take a long, hard look at this. And there is no question that putting your head in the sand and saying, well, technology would do its thing, I'm going to do my own, is not the answer. I will say a word about trust, and then I will talk about perhaps possibly a practical example of something that might be helpful. The question of trust is very central to dispute resolution, and particularly to a private means of dispute resolution like arbitration. Nobody forces, unless we're talking, I'm not talking about mass arbitration and in consumer claims, which is a very niche example, but generally in commercial relationships, no one is forced to go to arbitration. And if they don't want to go to arbitration, they can ask to be taken to court. So it is very much something that is the result of party autonomy and placing their trust in a decision maker that is private. And so the question of where the trust of the people who transact online, who are part of the Web3 economy, who are part of 21st century commerce, where that trust will be placed, what they will see as thoughtfulness within the rule of law, is my third open question. I will finish with a very small example, practical example of having been in the high spheres of philosophy for most of my intervention. I co-chair a working group at the International Chamber of Commerce on allegations of corruption in international arbitration, which is a very difficult topic because we all agree that corruption is, and there are treaties, that corruption is not a good thing. How can arbitration, where you have allegations of corruption before you, how can you be part of that governance that stamps out, that does not allow arbitration to be used by corrupt actors? And one of the things that's very difficult for humans to do is to identify in this year of corruption indicators, what are called red flags. And we have been looking with experts advising us as whether algorithms could help the human mind see patterns of behavior in data that would point to red flags and that would allow arbitrators to at least be able to question the evidence that is put before them in a way that they cannot now, because the volume of evidence is very large, and also obviously corruption is opaque by definition. So this hopefully will be a very good example if it is taken up by the ICC, of having a partnership between technology and human dispute resolvers that allows a better understanding of dispute resolution as a factor and as a mechanism for governance. I'm going to stop here. Thank you.
Thank you. Is this still already on? Okay, great. So Nathan, I think it's over to you.
Fabulous. Let me just, okay, looks like it's working. You're seeing the screen okay?
Yep.
All right. Thanks again for the opportunity to share here and for the chance to be on this panel. I'm going to report on some early work in progress. This is the first time I or any of our team has shared this work publicly. So bear with us and bear with me and have mercy. The frame of the question that we were exploring is how to provide tools to support dispute resolution. Might not be the right word. We usually just use the word dispute protocols in informal communities. So in particular, we think of these communities as online, but not exclusively. We think that the kind of work we're doing could be useful in other contexts as well. But it also starts to the recognition that a lot of online spaces, including, for instance, in Web3, are running under the radar of, say, on-chain dispute resolution processes. Even, say, in the context of a DAO, a lot of the dispute processes don't even rise to the level of needing to be or being relevantly on-chain. They're essentially interpersonal. And we're interested in how to build digital tools to support the resolution of those interpersonal conflicts that we believe have been really destructive in the context of a lot of online communities that we've been part of. My main collaborator, Dorothy Howard, for instance, is deeply involved in a wide range of Wikipedia communities, and she has seen this problem come up again and again. I've seen it in the context of mutual aid groups and a wide range of social movement formations. So we, at least anecdotally, have seen a really profound need. And we're also working out of the assumption that I articulated in my most recent monograph, Governable Spaces, of implicit feudalism, which is the idea that our online tools have been designed around the assumption of admin control, of a kind of top-down control. And as a result, we've really atrophied the development of participatory collaborative governance practices in online spaces, to say nothing of offline spaces, but particularly online. And something that my lab has been involved in for years is trying to figure out, okay, how can we build out some of those tools? And I think the Web3 universe has demonstrated that when you actually invest in tools for online governance, some really interesting things can emerge. But outside of Web3, this has been, largely this challenge has been largely ignored. I've also experienced the way in which simple tools can make a big difference. A close collaborator of ours, and also someone whose work I've benefited from directly is Coraline Ada Emke, who's an open source software developer who designed the Contributor Covenant, which is a simple 1-2 page code of conduct. And I've experienced what it's like to go from a community that didn't have a code of conduct to one that adopted the Contributor Covenant. And suddenly, problems that were previously seemingly unsolvable could be solved relatively straightforwardly because we just had a shared set of agreements. And so experiences like that have indicated to me that simple tools, even if they can't solve every edge case, can actually make problem solving a lot easier than not having those simple tools in place at all. And it's with that idea that, for instance, over the years, we've been developing this tool called Community Rule. It's in the process of being redeveloped right now, but it's a kind of builder that enables communities to essentially develop simple bylaws. So we have templates where people can choose the benevolent dictator or consensus. So you have a very simple template, and then you can fork it and edit it and change it as you like. And we're, again, in the process of rebuilding this tool right now to make it much more user-centric and accessible for people who are not used to designing bylaws. And this is kind of a parallel process to what I'm about to share. Also, as Federica mentioned, we've been involved in this work with Federica around what we call governance archaeology, and now more broadly, governance ecologies. And this is an effort to catalog and learn from and connect with a wide range of governance practices around the world. And so as we're designing our thinking around dispute protocols, we're integrating learnings from diverse governance legacies, not just the North Atlantic kind of dominant frameworks for thinking about conflict and disputes. For instance, one of our team members right now is really focused on learning from dispute practices in South Asia, particularly in Islamic contexts, and we're integrating that learning into the design we're doing. Okay, so the basic prototype that I'm sharing here is, again, very much a prototype, exploring what it might look like to facilitate the creation of simple dispute protocols that with the goal of coming out with a simple framework that communities can adopt, and modify and adapt. So this is a tool I've been playing around with. It's a JavaScript toy, essentially, but it enables a community to develop, to fill in all the pieces that they might need to have a basic dispute protocol. And so it has a set of categories here, and in each category is a series of questions. How does the process begin? Where does the community keep its rules? So how do we know what the rules are? Who has access to information about the process? How are other participants brought into the process? And we're right now really trying to think about, how can we reduce the number of questions? How can we just make this kind of easier to come to? And one important step that draws from what we did with Community Rule is it's got a template system. So you're able to pick an example template, say, drawing on the tradition of restorative justice, and it will fill in many of the boxes. The templates don't necessarily have all the answers to every box. And then you can see that you have a kind of basic coherent framework for a basic restorative justice process. Or you could say, no, actually, my community is, doesn't have any facilitators. We really need these conflicts to be addressed person to person, kind of ultimate Frisbee style. If you're familiar with that sport, it's a sport that does not have any umpires or referees. Then we have a template for that. Templates are basically collections of what we call modules, and modules are potential answers to a given question. And so you can actually also choose a module a la carte, so to speak, at each, around each question. Or you can pick a template and get a whole set of modules altogether. So the goal here is to strike a balance between supporting communities in drawing on pre-existing legacies and things that have been thought through by others, but also be highly configurable. And then the tool can export a PDF or a Markdown file that can be added to a GitHub repo, or JSON that can be re-imported. So the goal is to enable dispute protocols to become just kind of an easy thing that communities are able to adopt relatively quickly. Challenges that we're wrestling with: one, generalizability. How do we make sure that this tool is really meeting the needs of diverse communities and cultures? How do we, there's a typo here. How do we make sure that it's adaptable for specific needs while also being generalizable? And then a key question I've been exploring is the goal for dispute resolution tools like this to support taxi drivers or rideshare drivers, in the sense of like a 1970s New York City taxi driver is somebody with a huge amount of expertise that takes years to develop. A rideshare driver, is someone who relies heavily on an automated map. The skill level necessary for, say, facilitation might not need to be that high because the guide helps you through it. And we've been really struggling with the question of, how much facilitator expertise should we be assuming and leaning on, as opposed to how much should we be trying to guide somebody who has no experience through the process. And then accessibility for newcomers is really essential. We've really experienced that with Community Rule, and that's why we're totally rebuilding the tool, because the first version is just not accessible in ways that we would like. Thank you so much. Really looking forward to the discussion, and I'll leave it there.
Great. So I think I'm going to do a follow-up on the project that Nathan has talked about, which is a nice, can you help me get the slides? A nice follow-up on a part of the larger project that Nathan has presented as governance ecologies. So I'm just going to, the Decentralised Carugati KCL.
Sorry about that.
Okay. So I think the nature of the project here is to sort of, as I said earlier, to contribute to the conversation by expanding the range of places where we look when we are trying to get ideas and sort of like insights about what kind of mechanisms we can design substantively and procedurally. And so how do I move forward with this? Great, thank you. Thanks a lot. So this is not so much good as a follow-up. I think that for me, as a historian, as a political economist, the tradition of sort of like that inspires the way that we think about justice, the way that we think about institutions for justice dispute resolution, is fundamentally Western. It's fundamentally connected with the body of institutions and knowledge that we have derived from a particular way of thinking about what justice is and how it comes about. And as Federico is a fan, this may be seen as going back all the way to ancient Athens and systems of lottery selection that sort of achieved some of the goals that we associated with justice. It might be even when we sort of think about traditional decentralized dispute resolution, it might even come from places where that type of justice that we associate with sort of a state-led institutions does not exist. And so what kind of justice and what kind of institutions we have for dispute resolution looks dramatically different. And I think that the inspiration behind the project with Nathan was to take seriously the challenge that justice and institutions for dispute resolution might come from or might be sort of productively contribute to by looking at different traditions, took us to explore essentially communities in history. This is not a slide that anyone is supposed to read. It's just to give you a sense of what the data that we have collected looks like. And that is essentially an attempt to sort of document and code various communities across history and around the world that developed systems of largely what we're looking at is collective governance, a part of which has to do with dispute resolution and justice making. For lack of a better word. So more specifically, in the course of the last 3 years, we have quoted about 90 communities that display at least one of these collective governance institutions. Some of these have to do with decision-making, as we would sort of in context of sort of legislation, but some of it has to do with dispute resolution and enforcement mechanisms in particular. So the kind of stuff that we look at are the actual micro-foundations of these institutions, how people get into the institutions, who gets access to the institution, how people make decisions, and once those decisions are made, who gets to enforce them. So earlier, someone mentioned the fact that, you know, like the Iceland or England in the 17th century did not have public prosecutors or police forces. Well, that's the nature of justice before the 19th century all around the world, where states and nation states as we know them today simply did not exist. And so once we stretch the boundaries of like where we look at the possibility of looking for decentralized justice expands dramatically, because this is not just something that happens online or on chain. It's something that has been happening for millennia in human communities. And so we are trying to essentially get a glimpse of what those experiences look like for two reasons. One, because I'm trying to keep my job, and as a political economist, I need to sort of write things that matter for scholarship. And so the idea is to bring the experience of decentralized justice institutions and decentralized decision-making institutions to contribute to a theory of collective governance, but also to think about communities of practice and what we might contribute to conversations and developers and entrepreneurs such as Federico and others in this room that are actually thinking about how to build these systems of chain, on chain, and so on. And so Federico thinks about decentralized dispute resolution. I think about citizen assemblies, but basically this sort of a body of information and evidence is meant to contribute to those conversations equally. And so some of this stuff comes from work that Nathan and I have done together over the course of the last few years, and some of this stuff sort of like graphically resides in the MedLab host that Nathan presented earlier. So the idea here, just to give you a sense of what this looks like, and very briefly, because I don't want to take up a lot of time, is that we've tried to sort of like span both geographically and temporally millennia. In fact, the data of the earliest communities are dated from the 4th millennium BCE. Of course, there is the evidentiary. It's very difficult to understand how people made decisions when the evidence is archaeological, but basically we've tried to gather as much information as possible. We get a different range of community sizes. This is particularly relevant because political economy and political science has and governance studies have very specific sort of assumptions about what size does to communities trying to make decisions on by themselves without a third-party enforcer. And so we're trying to gather information about decisions in these various contexts, size-wise, temporally, and geographically. And what we find, again, very briefly, and this is, again, pretty early stages in terms of the analysis of the data that we have, is that the governance systems, dispute resolution systems, decision-making systems that we tend to associate with European-based mechanisms, think that we associate with the tradition associated with Athens or any place in pretty much in early modern Europe. So systems that will use the mechanisms like the lot or deliberation or quorums or majority rule tend to be associated with a particular geographic location. And so without sort of like going into too much of the details of the data, there is a clear sort of like a clustering of mechanisms that are associated with European and Western traditions of dispute resolution and collective governance mechanisms, and traditions that are associated with different geographical regions. Now, of course, when you're trying to query or gather information about what's going on in indigenous communities in South America, the data tends to be slightly less complete than 17th century England, for example. So deriving pattern at this point will require a lot of additional work. I don't want to get into too much of the sort of the weeds here. But the other result that we get from this preliminary analysis is that in the same way in which we see regional patterns of governance, we also see patterns associated with size. So against a sort of like a social scientific assumptions that as size goes up, collective action and collective decision-making becomes more complicated, we see diverse mechanisms essentially catering to these sort of like processes at different sizes. And so we hope that part of this sort of, as we get more granular about what these mechanisms are, people that are trying to design mechanisms for dispute resolution or collective governance more broadly will be able to draw on a wider set of mechanisms and in some sense sort of like a do or add a historical empirical basis to the work that, for example, Nathan was talking about in tools, in available tools, such as community rule. So that's the idea behind the project. You'll see Nathan's name up there alongside a bunch of others and some of our funders. And thank you to Federico for inviting me here and for organizing this wonderful conference and everyone else. And so I'm going to stop here and maybe open it up for questions. We've got 10 minutes. Okay.
Thank you. You mentioned civil assembly, was it?
Yeah, citizen assemblies.
Citizen assembly. Yeah. Can you elaborate on that a little bit more?
Yeah, I think that again, like I am not so much a technology person. I am more of a historian person. And so when I think about the contribution of history to sort of like questions of decentralized governance, for me, what this comes down to are offline experiments in participatory governance, of which we see now and in the last 5 to 10 years, what has been termed a new wave, a new deliberative wave. So a lot of people very much interested in building spaces for collective participatory inclusive governance that are happening sort of like in the here and now of sort of real spaces or offline spaces where the design of those spaces, like who gets in, how the decisions are made, who votes, what kind of deliberation practices are used, what's happening once the decisions are made, are all sort of like left to the creativity of designers. And there is nothing wrong with that, to be clear, but I think that for me as a social scientist thinking a lot about this stuff, the attempt is to bring some sort of like experimental or sort of empirical basis to the conversation by looking at how human communities in the past have organized and created these spaces as well.
So have you considered your restructuring mechanism, calling it Schillig point? But no, seriously, I have a thought about the parties facing the restructuring event and the symmetry of gains and losses that they experience at the point of the restructuring valuation. Namely, I could see a world where sophisticated parties systematically expect certain types of gains, not always and everywhere, but in expectation. And so unless those losses and gains at that restructuring moment are symmetric with respect to the parties, some parties might not want to contract into your mechanism if they're systematic beneficiaries in expectation of that moment of restructuring. So is there an assumption about kind of randomness or symmetry among all those contracting in that they would prefer the certainty as opposed to an asymmetric, uncertain outcome?
That's an excellent question, and I think it also relates directly to one of the concerns that Barry Adler had to face with his initial chameleon equity proposal, and when he was wondering why it hadn't been taken up, because it's so beautiful and so efficient, but why is no one using it? Because it would be possible to have something similar just based on traditional contracts. I mean, there is a difference, obviously, because with a traditional contract, you still need to mechanically exchange debt for equity and so on, which in a smart contract world you don't. To cut a long story short, we haven't really modeled that problem, but it is a real problem that needs to be addressed if it ever were to become practical. So thank you very much for that point.
Great panel. I have been following the archaeology governance for a while now, and I mean, congratulations. I'm seeing it growing, and this is a very big list now. I have a question about, we at Kleros, all the time we are looking at previous time, governance models, in particular justice systems to improve our mechanism. I ask William quite often with new things I read from anthropology, from history, and I recommended to him to read about the sagas in Iceland and the private prosecution system in the UK in the 18th century. But I mean, we are biased to Western tradition. That's what we know, and that's what we read mostly. What would you recommend? I mean, readings, or what should we get inspiration from other areas, other traditions that maybe we are not aware of?
We have a very long conversation about this, which we're not going to have.
We will with the drinks later if you want.
In this space, but I think that the problem with known Western traditions is that they're not written, or they did not sort of like they are not available to us, and by us I mean me, speaking a limited number of languages, with my arrays also speaking a limited number of languages. They're not as available as and as well packaged, some might say, as the traditions that come to us from the European tradition for a variety of different reasons. Some of it having to do with violence and some of it not. And so the question is like how to mine that evidence. And this is a question that has really sort of like not just practical limitations, but also fundamental ethical implications that Nathan and I wrote about and have been writing and thinking about, because the moment you sort of like move into a space where you don't know language and cultures and you try to sort of like code practices as data, you enter a space where you might be misinterpreting 90% of what's going on. When your evidence is, diaries of colonizers, you enter into a very complicated space. So just to make sort of the story short, this is actually a very sort of like a complex methodological issue that we're trying to address. But in terms of sort of, this is at the level of data collection, at the level of sort of like a higher level contributions, there's a bunch of recent work by anthropologists that is absolutely worth, and political scientists that is absolutely worth getting to know. So we can talk a little bit more about that.
Good. Is there another question? Yeah.
Oh, Nathan.
Yeah, Nathan, go ahead.
I could say a bit about on over at MedLab a couple things we've been working on in that respect. I mean, I think it's true that we are really lacking easy things to point to, and that's what we're trying to address. But a few examples of just the power of this kind of approach is, for instance, we're working on a paper right now that draws on legacies from indigenous communities in South America generally. And in the process, we're kind of leveraging these in the context of a critique of the legacy of cooperative business, which is largely centered internationally around the experience of the 1844 Rochdale Cooperative in England. And what we're arguing is that if you look at this broader legacy, in these particular cases, there's actually a really broader, there are many more possibilities for how to approach governance. For instance, the use of elders, the use of stake, actually. And there are some respects in which some of these indigenous practices, which center like stake and investment, could actually be more appropriate for thinking about decentralized kind of blockchain-based designs than, say, like the 1844 model, which was developed in the context of trying to achieve voting rights and, adopted this kind of one member, one vote structure. Again, as I mentioned earlier, we're looking at cases coming from South Asia, traditional dispute resolution practices like the Salish model and a model called the Madaripur model of mediation from South Asia. In these contexts, they're really built around village-level dispute management, and in many respects, those might be more appropriate for, say, an online community or a DAO than practices designed for corporations in a Western legal context. So we found that there's a lot of benefit in being able to broaden our frame, but it's true, it's hard to find things that you can just point to and tell people, here's the guide to like the non-Western governance practices. And so we've been thinking a lot about what kinds of publications and tools can we be providing to address those concerns or to meet that need.
One last question. This is for Sophie, but I guess anyone can answer. So over time, we have seen like most of the interest about decentralized justice comes from, mostly the UK and also the US. Do you think there is some connection between the legal tradition? Maybe because of the common law? I don't know. It's just an idea I have. I don't know if you feel the same or not.
Thank you. There's certainly a parallel. I don't know that I can establish a cause and effect linked, frankly, if only because your venture is so young. But there is definitely a parallel between the way that jurisprudence or case law, as it's called in this culture, is built, as opposed to, in a more continental perspective, the application of a centralized code by a group of courts in a similar manner. There's also the system of stare decisis, which is the fact that higher courts govern as opposed to what the lower courts decide. And there is a precedent system which does not exist in your model, and maybe it could. I think that perhaps is something that if we want to establish a parallel with the way that the common law is developing, and I am no legal historian, I'm just talking from the trenches, maybe the precedent system might be something that Kleros might want to explore in order to complement what you already have. I hope that's sort of an answer.
Yes, this. It's interesting, this approach that Federico does, because when we think about the legal tradition, this differentiation of common law and civil law, it is really recent. It is only like 19th century. So right now we're dealing with this phenomenon of AI that could lead us probably to another source of law. Because the idea of source of law, it was not invented, but it was created in the 19th century by Savigny. So right now that when we realize that we have an AI agent that could help to create law instead of applying the law, it is another issue. Like instead of jurisprudence, we are talking probably on legisprudence. So the rationality in creating the law instead of applying the law. So it is a major issue that I invite to think about. We were talking previously about that. I have a little paper on that. I would like to share it if I may. But I think AI, it comes to reshape a lot of things. I don't know if you think something about it.
Yeah, I think that's very interesting. I just wanted to make one additional point that ties in with what both Federico's question and what you just said. In my view, the differences between common law and civil law are usually exaggerated. I think there might be a very simple reason why, in particular, predicting outcomes with large language models is a very hot topic here and in the US, as in Germany, it's not a topic at all. And the reason for that is not how civil law and common law work, but in Germany, all the legal material is behind a paywall. So the models cannot access this legal material. Whereas here in the UK, all the cases are online, and you know, if you have a model, you can just scrape the internet and you have immediate access to all this legal information. Whereas in Germany, you don't. And so in Germany, it's developing in niche areas through proprietary models. That have access to that data, and they build these little models that just use that particular data that they have. So it might just be these practical, very practical things rather than inherent differences in how decisions are being made. But I would be very interested in your paper and this sort of emerging sort of technological normativity as distinct from the more traditional types
because
of
probably we're talking in an upper layer of digital thinking or a legal culture layer. Who's next?
It's telling me that it's time for coffee, so I think it's time to close. Exactly. Okay, thank you.